Justice Mansfield, thank you for that wonderful introduction. The only downside to it is I have to try and live up to it now. And, I'll do my best. Let me talk about consumer protection first, and then after that, antitrust. We've made some what we think are important decisions in the area of consumer protection in recent years, and made probably the most important decision on how we operate many decades ago. And that decision was that when we look at consumer cases or antitrust cases or similar cases in our office, we basically look at three criteria. One is how egregious was the conduct. Second was how extensive was the harm, and the third is what are our chances of winning in court. So those in terms of major cases and major priorities, those are the three criteria. And the decision we made a few years ago, really largely with the coming of Jeff Thompson to our office. Jeff was our litigation deputy. He's our Solicitor General now, and he and she's changed in some ways, some very good ways how we litigate and how we handle cases. And one of the decisions we made was to litigate more civil cases. We certainly litigate enough criminal cases. The area prosecutors do that all over the state, all the time. But as you know, there was a drop in the number of civil jury trials in our state and around the country, and we've sort of gone contrary to that. And one of the areas that we really sort of thought that was important is in consumer protection, in the sense that there are consumer frauds that either borderline or cross the line into their business plan. The fraud being part of the business plan, being fundamental with the company, so that you know it's pretty hard to resolve a case when that's the case. I mean, they're not going to give up something that's fundamental. If you don't get them to give it up, you really don't accomplish very much. And we saw that a little bit in Iowa, and we saw it around the country in some of our multi-states. And one of the main areas that sort of jumped out at us was membership buying clubs, or adding on services or features. And you've all experienced it many times over. One way is you have something's wrong with your credit card bill, or you think it is. You call up and you get that resolved with your credit card company, and then you're about to hang up, and they say, "Oh, would you like to have this? Would you like to have these free services for 30 days?" And you say, "Well, no, I'm not really interested." But you know, there's a sort of a quality that you sort of want to agree, and you want to get off the call because you got something more important to do than this conversation, and they're a little bit persistent. And they say it's free for 30 days, and so you say yes. And there's a whole variety of ways they do that. Sometimes it's a gift or some sort of product, and in the fine print you're signing up for the membership buying club. And the whole idea is to slip this by people and get them signed up without being very conscious of it. And it is free for 30 days. And it's, it can be a variety of things. The most common is some discounts if you buy products, which are fine if you're going to use them, but not particularly substantial. But the whole thrust of it was that after the 30 days, when they can start charging you, they have to send you a notice, right, that they're going to charge you, and also a list of your opportunities. So what does the notice look like? What do you think? Well, it's the biggest piece of junk mail, apparently, that you could ever see, and you flip it aside, and then you get charged, and they sort of focus group this is to the amount, and it's anywhere from $9.95 a month or to $12 or $13 a month, and the idea is that you don't recognize it because you don't remember that brief conversation. You didn't really know what you're authorizing, but you think it's not a lot of money, so you let it stay on for a period of time, and eventually you probably get it off somehow. Sometimes it goes on for a long time on your credit card, but the whole idea of the sort of the thrust was to sneak this by you. And very few people use the services, almost none, and they keep collecting. And we AGs would have settlements with the companies, and Vertru was one of 3 main companies. And we'd get a little better disclosure, and there are certain things they couldn't do on the phone call, but it wouldn't change the result. They'd still be able to operate. So we decided that they, when we showed ourselves up as very interested in this, they wanted to negotiate it. We're always willing to negotiate, but I sort of doubted we'd be able to negotiate something, because what we wanted to do is have no deception, no fraud. But if they did that, that would take away their product, basically, their whole way of operating. So we weren't able to settle. So we went to trial, and it was an extensive trial. It was bifurcated between liability and damages, and we got a very good ruling on liability and on damages. And the damages were, I think, in the area of $28 to $29 million that Iowans had lost to this company through that scheme. They claimed that they were right on the law. We were wrong. They wanted to appeal, which turned out to be a good thing for us, because to appeal they had to put up an appeal bond, and the appeal bond was $32 million. The case went up to the Supreme Court of Iowa, and the Supreme Court ruled for us on a few issues that we lost at trial, and really increased I think the amount would have increased the amount from in the area of 38, 39 million. But we had the bond for 32 million. In between, they went into bankruptcy, and we'll come out of bankruptcy, no doubt. But we had the bond for $32 million, and we're able to distribute that to Iowa consumers. And there were a number of other companies that also were doing something similar, and we were able to settle with them. So it was about $40 million for Iowa consumers as a result of our decision to go to court and to try this case. A lot of work was put into it. It's fairly complex, because you really most of what they say, if you isolate it, is not deceptive. But you have to look at the total picture of what they're trying to do to see the deception. And there was a remarkable, in our view anyway, Iowa Supreme Court decision, and it was remarkable to me because of 2 things. One, the opinion demonstrated quite clearly that the Supreme Court had incredible knowledge of consumer law and mastery of that, which wasn't too surprising given this court. But also, they had an incredible knowledge of how consumer fraud works, and the 2 taken together, gets to these various schemes that are disguised and misdirected in an incredible way. So it turns out we were the only state to try the case of the 50 states, and at one point we had recovered more money from this company for our consumers than all the other states combined. Eventually, I think they went over us, but not by much. So that is something that's in our way of doing things. That if there is a significant fraud, perhaps often a complicated fraud, that we can only settle if there's a settlement. It's only around the margin. It's not going to cure the problem. We're committed to try the case, we have a remarkable assistant attorney general by the name of Steve St. Clair, that is a total bulldog when it comes to some of these frauds and some of these companies. And he was the lead on this and did it pretty much alone for a number of years, the investigation. And then Jeff Thompson tried it with him, and Juliet was involved as well. There was a great team, but it goes to something that we're trying to do more and more of, and that is to try and figure out what is the result, what is the real effect of what we're doing. And we can do a lot of things that appeal to us, that sound good, but what's the real effect? And Steve St. Clair is our guy there. We had a settlement with the sweepstakes companies that have their own version of fraud in a variety of ways. One is the implication. You don't have to, on the sweepstakes, you don't have to buy anything to be eligible for the prize. But they have some of them had a really sophisticated way of strongly implying, or people would believe, that if they bought, they would have a better chance of winning. And it was focused largely on elderly. One thing we do find out is that frauds that seem sort of neutral as to age on the surface are focused more on elderly. There was one Iowan that was getting mail from at least one of the sweepstakes companies every second day that mail was delivered. So we had a settlement among the states with them, and we were more vigorous, or maybe unfair, in how we enforced it, with the result that basically the sweepstakes companies have left Iowa, and the fraud that they have perpetrated is not here. True basically left Iowa, and the other other membership buying clubs did as well. So I mean, we can make an argument that that we're an island in some ways on this, and a good island, in part because of the decision that I mentioned before, and in part because Steve St. Clair's persistence. We continue to work in a number of areas going forward. Telemarketing is an area that we're concerned about. There's a few more versions of that as time goes on, and that also is practical matter targeted very heavily at elderly people. In part because they have more landlines, they're home more often, they're more willing to answer the phone with an unknown number than maybe others. The terrible tendency of repeat victimization, that if somebody is a victim of telemarketing fraud and often other kinds of fraud, the perpetrators will go back and repeat the fraud. And then the worst thing yet, sell that name to someone else who will do the same thing. We do a lot on home repairs on a day-to-day basis in the Attorney General's office. That's an area where there's difficulty, let's say, dealing with some of the home repair folks, and there's not a lot of hammer that we have, but we continue to do our best. And it's somewhat difficult, but it's very important to people in the home, and the expenditure on the home or on home repairs is a very substantial expenditure. We do work on automobiles, used cars as well as new cars. Probably more in used cars than new cars. And we sort of look at, as we look for priorities, we look at the largest purchases that consumers make. The largest would be the home and or the mortgage. Second would probably be education. Third might be automobiles, and somewhere in there, and maybe higher than fourth, probably higher than fourth, would be credit cards. So we look at those areas fairly closely because they are so important to consumers. And then we're trying to talk about difficulty. We're trying to struggle with those calls that you get that you don't want. that have become more numerous over the last few years. And the do not call list worked fairly well for a period of time. Still does in many areas, but there are people that will violate that. They're often located in foreign countries and very hard to trace down. One of the things we're trying to do, the state AGs have petitioned or supported a proposal with the FCC that would give the phone companies the authority to give us users of cell phones and phones the option of blocking all calls where the phone number has been switched from the real number. Now they, it looks like a local number, but it's really from a foreign country. If they do that, then we could block that call if the FCC approves this, and that would help a little bit, but still be really difficult. A lot of what we do in consumer is with multi-state cases, and multi-state cases are both national cases and Iowa cases, in the sense that if we didn't have a multi-state option, we would probably file an Iowa case and choose to be part of a multi-state only because it's more effective, more efficient, and we could get a better result. But those cases continue to be incredibly important, and of course are part of what I would view as the rich history of state AGs. We started doing multi-states in the late 70s. In the 80s, Ronald Reagan became president and pursued an agenda that was a little different than other Republican presidents in a way. The way I phrase it is, or think about it, is that on trade regulations, antitrust, and consumer, when there's a Democratic administration, it's sort of a center-left operation. When there's a Republican administration, it's center-right. But there are things that we can all agree on and work together on. With Reagan, it was an attempt to redefine deception, redefine consumer protection, basic law at the FTC level, and it was an attempt to redefine and to change antitrust law, and that's where the states really rose as an antitrust group as a result of that, coming out with alternate guidelines and then forming a task force of state assistant AGs to do that. And then lo and behold, the tobacco case came along, which was bigger and different than any. And now quite a bit of work on the for-profit schools. In antitrust, we really are very dependent on the federal agencies, the Department of Justice and the FTC, because they have a lot more resources, and antitrust cases often are very complex, time-consuming, and costly. So for a resource basis, we partner with them a lot. Recently we were their partners on the two health insurance mergers, Aetna and Anthem, and both of those were tried and successfully tried by Justice and us to block the merger. We're spending some time on the Bayer-Monsanto merger that has potentially a lot of effect on Iowa, and again working with the Justice Department, and anticipate that will continue. I have a little trouble pronouncing the nominee for the Assistant Attorney General for Antitrust, but I'll do my best. Makan Delrahim is the nominee for the Antitrust Division of DOJ, and is a well-respected antitrust lawyer. Was in the second Bush administration Department of Justice and the Appellate Division and I think is seen as a respected figure in the field. I'm anticipating, hoping that the states can work well with him. At the FTC, it's a little bit up in the air as to who the nominee will be. There were sort of two early front runners, at least according to the press. One is the current commissioner, who's the acting chair, and that's Maureen. Oh, how's it? Again, a little trouble with the pronunciation. I hope I'm close. And the other candidate was a friend of mine, Sean Reyes. He's the Attorney General of Utah. But time has gone on, and neither of them have been nominated. So the thinking is that probably neither will. And there's a little bit of a focus on Joe Smith, who's an antitrust lawyer, an antitrust enforcer, who I think also has a good reputation. In the antitrust field, a couple of ongoing cases that we're involved in. One is Suboxone. That's a case where the patent is running out, and then there's an attempt to create an alternate product in a new patent period. And then what's really pretty exciting is we're working with Connecticut. The Connecticut AG's office in antitrust and consumer is just a terrific office, and one that we worked with very closely. They're our friends, and they've led the states into an antitrust investigation of some of the generic prescription drug companies in the area of price fixing and bid rigging, which is somewhat surprising to me and very concerning. So we will be working with them and are at this point. Justice has some cases too, but they're really, I think, pretty separate. With that, I'll be glad to answer any questions, and I don't want to steal time from Nick either. I see him back there. He's ready to go, it looks like.
How about the cell phones? I know a couple of years ago you folks did a lot of work in that area. See much lately, all these plans and ads.
Yeah, the charges. We've done a lot on that. We really value the single price. So that the single price, rather than there's the basic price and there's this add-on, that add-on. The single price is something we've worked together on AGs a long time, starting back in the 80s on rental cars. But that's so important because it's so much clearer, so much easier for consumers, and also it's good for competition. Because if there's one price, you can have price competition pretty effectively. But if it's a basic price and there are a lot of add-ons, and it's really hard to tell which costs more than the other. That's something that really defeats price competition. Yes.
Do you have any thoughts about the Equifax security breach, maybe more particularly the response to the breach and other criticisms that they were at one point doing? They might actually profit off the breach by charging for credit monitoring and so on.
Yeah, we have quite a few thoughts about that. It did catch our attention, and there's a number of things that are at play there that are troublesome and difficult. One is that when a company is dealing with a lot of individuals, with a significant number of individual transactions, which we experience with them primarily, and where they had made mistakes on people's credit and how people want to get it corrected. And we saw it incredibly in the mortgage area, where people wanted to get modification or they wanted to get forbearance. That when you have a huge number of transactions, it's a real challenge for the company to make that work. And unless you really are committed to making that work and spend some money to make it work, it doesn't work very well. And when we were dealing with the credit bureaus on the question primarily of fixing false information, they certainly didn't have the zeal to make it work. They were pretty they were pretty lackadaisical about it. We had to push to get what we could get. And some people have suggested part of the reason for that is that the people that are calling them are not their customers. Their customers are businesses, so they don't have to maintain a loyalty of the customers. And then when this hit, you know, it took them a long time, about 6 weeks, to disclose this to the public and to people affected. They have a reasonable time to make that disclosure. That really is pushing it. In fact, one of our assistant attorney generals said that he's dealt with 20 or 30 data breaches, and never has any one of those has it been that long before it was disclosed. Then they had a scheme to profit they would offer protection that would run for a year. And it's a little bit like that Virtue situation I was talking about. If you don't cancel within a year, the protection continues, but you get charged for it. So they're sort of trying to make money. Then there's the allegations that some of their major officers sold stock after they knew about this problem. They deny, I think, that those officers knew about it, but the Justice Department or the SEC is looking at that. You know, it just when something like this happens, a company really has to get worried, get energized, and do everything, move heaven and earth to try and solve the problem. Particularly here with those security numbers being part of what was disclosed. Usually that's not the case. That's not where they've been. We had a lot of calls. We were suggesting early on, which we think is good advice and still do, that people get a credit freeze for a period of time. And basically that would mean that if somebody tried to use their credit card or their identity to purchase something or to get a credit card, they would check with Equifax, and Equifax would not provide any information, and then the credit card company would not go through with the transaction. Well, you know, they gave us a number, and that they would take care of this, and people started calling the numbers, and the weights, and it was totally inadequate service as to the people that were calling in. So people were calling us and upset at us a little bit for that advice, among other things, but which we could sort of understand. Any other questions? I think I am trenching on next time here. You know, thanks for having me, and thanks for the work you do. We think antitrust and consumer law is a very important area of the law, and appreciate your work in that area. Thanks again.